Well, thank you all for joining us. We have a nice group of panelists that are with us, and then we've got our other folks who are attendees who are in right now. So we're going to go ahead and get started if everyone is okay with that. My name is Lester Davis, and I am happy to kick off today's very important virtual press call about the federal lawsuit against the disparate impact rule from the federal HUD. I want to introduce our guests who are going to be with us. We have Lisa Rice, President and CEO of the National Fair Housing Alliance. Ashmel Khosrari, Senior Counsel, NAACP Legal Defense and Educational Fund, Incorporated. We have Carolyn Peedy, Executive Director, Fair Housing Advocates of Northern California, and John Relman, Founder and Managing Partner, Relman Colfax. I want to turn things over to Lisa, who will kick us off this morning.
Good morning. The National Fair Housing Alliance is the nation's only national civil rights organization dedicated solely to eliminating all forms of housing discrimination. Today, we, along with other plaintiffs, filed suit to block the Trump administration's attempt to roll back a major tool for fighting injustice, disparate impact. Last month, the administration eviscerated HUD's 2013 disparate impact rule and replaced it with a new rule that will make it almost impossible for victims of discrimination to challenge policies and practices that have a harmful effect on communities of color, women, people with disabilities, and families with children. Our country is facing a triple pandemic: the COVID health crisis, the ensuing economic crisis, and the crisis of racism that has plagued us since before the inception of this nation. COVID-19 has been the great revealer, exposing the fissures in our housing and finance systems that unfairly lock people out of the opportunities that they deserve. In the aftermath of the unjust murders of George Floyd, Breonna Taylor, and too many others, we are in the middle of a national call for a reckoning with centuries of unjust practices, lack of enforcement of civil rights, and structural racism that have all served as barriers to advancement for people of color. Residential segregation and housing discrimination lie at the root of many of our challenges. In this nation, where you live matters. Your address determines almost everything about you: your chances of graduating from high school or college, getting arrested, your net worth, your income, your ability to own a home, your credit score, and how long you'll live. Your zip code is actually a better determinant of your health than your genetic code. Residential segregation is the bedrock of inequality because it serves to direct which communities will receive certain resources and which areas will be deprived or starved of critical investments. The effects of redlining, residential segregation, discriminatory policies, and disinvestment have created a scenario where people of color do not live in areas with ample access to healthcare facilities, green and healthy environments, clean water, quality credit, healthy foods, high-performing schools, and other important amenities that people need to thrive. These structural factors, coupled with implicit and overt bias in our healthcare system, are really what's behind driving these horrible outcomes related to the COVID-19 crisis. And one of the most effective tools for fighting these structural barriers is disparate impact. Civil rights advocates have used disparate impact for almost 50 years to fight discrimination. The National Fair Housing Alliance and our members have used disparate impact to compel insurance companies to drop policies that had the effect of redlining communities of color. We've used disparate impact to stop the discriminatory maintenance and management of bank-owned properties in neighborhoods of color. We've used disparate impact to preserve the housing rights of survivors of domestic violence. NAFA is also using disparate impact to challenge algorithmic bias. In fact, just this month, we launched our Tech Equity Initiative, which is designed to eliminate discrimination in the technologies used in the housing and lending sectors. We are using disparate impact to help reduce the racial wealth and homeownership gaps under our Keys Unlock Dreams initiative. Disparate impact is a critically important tool for fighting injustice. This tool is so vital that corporate America is calling for it to be preserved. Just last week, in fact, the Business Roundtable issued a statement of support for disparate impact. Some of the nation's largest financial institutions and housing trade associations, including the National Association of Realtors, the Mortgage Bankers Association, the Housing Policy Council, Quicken Loans, Citigroup, JP Morgan Chase, and many others have called on the Trump administration to not take this devastating action. When it is all too clear that what we need are tools to help us fight segregation and discrimination, President Trump has stripped away long-held fair housing protections, leaving millions of Americans vulnerable. This attack on disparate impact is yet another attack in a long line of assaults by this administration on fair housing. HUD's action in gutting the disparate impact rule directly undermines and interferes with our ability to fight discrimination and create a society that is fair and equitable for everyone. We will use every option that we have to fight this assault and protect the fair housing rights of everyone in this great nation. And now I'd like to turn it back over to Lester.
Thank you very much, Lisa. I appreciate that. Next up, we're going to hear from Ashmael Khashari, Senior Counsel with the NAACP Legal Defense and Educational Fund.
Good morning, everyone, and thank you for joining the call this morning in the midst of everything that's happening in our world right now. Over the last 5 months, since the killing of George Floyd, the nation's attention has been drawn to the ways in which structural racism harms Black communities in America. We have seen how racism extends beyond just policing to issues of education, as well as economic justice. Housing is no exception, unfortunately. It's in this moment of recognition of the effects of structural racism that the Trump administration has chosen to eviscerate the United States Department of Housing and Urban Development's disparate impact rule. The law, as acknowledged by Supreme Court, has long recognized that victims of housing discrimination can challenge policies or practices that harm one racial group more than another. LDF has played an active role in using the disparate impact standard over the last 50 years. We have used it to challenge policies that prevented African Americans from obtaining housing after Hurricane Katrina. We have used it to challenge background check policies that prevented any person with a criminal conviction from obtaining employment. We've used it to challenge discriminatory tax foreclosure policies, which resulted in individuals receiving tax bills that were worth more than the value of their homes. There's a good reason that disparate impact as a standard exists. The law has set an extremely difficult standard to prove what is known as intentional discrimination. A victim needs essentially smoking gun proof that someone is taking action against them because of their race. The intentional discrimination test does not fit reality. Oftentimes, a person taking discriminatory action doesn't explicitly say they are doing so because of a racial motive. And even if they do, the victim may not have a recorder ready to record such. This is why the disparate impact standard is so important. It provides that a person can challenge a policy or practice that harms one group more than another, even without that smoking gun piece of evidence. So long as they're able to show that there is a less discriminatory approach that is available, which would accomplish whatever the defendant's interest is. And really, what's the excuse if you're a defendant for not adopting a less discriminatory approach? Nonetheless, the Trump administration has eviscerated this standard, creating a new rule which imposes a variety of new procedural hurdles for plaintiffs, creates a variety of new defenses for defendants, and thus requires victims of housing discrimination to meet a standard that's essentially akin to intentional discrimination. I thank my colleagues for their work on this case. I thank the plaintiffs in this case for standing up on behalf of all Americans, and thank you again for attending. We look forward to providing further updates about the suit as we progress. Please stay safe.
Thank you very much, Ashmael. I appreciate those comments. Next up, we're going to hear from Carolyn Peaty, Executive Director, Fair Housing Advocates of Northern California.
Good morning. I'm the Executive Director of Fair Housing Advocates of Northern California. I've been working in the fair housing field since 1987 and have been the director of 2 fair housing organizations. Fair Housing Advocates of Northern California is a local organization, and we've been providing fair housing services since 1984. We currently serve several Bay Area counties by providing free counseling, enforcement, mediation, and legal or administrative referrals to people experiencing housing discrimination. We are a member of the National Fair Housing Alliance. I'm here today with our partners because we are very much opposed to HUD's final disparate impact rule and its radical revision of the previous 2013 rule. This new rule will seriously damage our ability to serve clients who are in desperate need of our assistance. Families with children who are faced with eviction or are barred from accessing housing because of restrictive occupancy or other discriminatory rules. Domestic violence survivors facing eviction due to unfair policies that disproportionately affect women. People of color who are negatively impacted by restrictive housing policies barring people with criminal histories, and others. HUD's new rule will have a chilling effect on the willingness of our already vulnerable clients to come forward with a housing discrimination complaint when the burden of proving that discrimination now appears insurmountable. Our agency uses disparate impact as a tool to assist many of our clients. We counsel clients and the community on how disparate impact law can be used to require less discriminatory alternatives to policies that have a discriminatory effect. For example, we received a call from a couple who had recently had a child and were given a notice to move because 3 people were not allowed in their 1-bedroom unit. This is an example of a restrictive occupancy standard that does not specifically prohibit children, but clearly has a disproportionate impact on families with children. This new rule will also negatively impact how we address issues of criminal injustice. Criminal record bans on those seeking housing have a disproportionately negative effect on people of color. We are currently working with Black residents who have been denied housing because of their criminal records, which in some cases are decades old. Denying an applicant based on criminal history without taking mitigating evidence into account, for instance, the nature of the offense and how long ago it occurred, can violate federal and state fair housing law using a disparate impact analysis. This rule undermines our ability to advocate on behalf of those clients despite the unfair application of these policies. We also tackle policies that result in the eviction of survivors of domestic violence from their homes. We recently received a call from a woman who received an eviction notice from her landlord because she had called the police on her abusive husband several times. Prior to the new disparate impact rule, if the landlord had failed to rescind the notice, you could file a complaint with HUD using the disparate impact theory. The new rule makes that virtually impossible. Finally, our agency is fully engaged in the process of helping cities and towns to affirmatively further fair housing. The Fair Housing Act of 1968 has a dual purpose, both to eliminate all forms of housing discrimination as well as residentially segregated communities. And affirmatively furthering fair housing fulfills that purpose. We help the jurisdictions we serve to analyze the impediments to fair housing choice in their communities, and using disparate impact is an important part of that analysis in order to frame recommendations on how to overcome municipal policies that are barriers to housing opportunity. HUD's new disparate impact rule undermines our ability to assist our clients and help the communities we serve to address systemic segregation and barriers to housing opportunity. It impedes our efforts to effectively fight housing discrimination rather than supports them. In short, this rule must come down. Thank you.
Thank you very much, Caroline. I appreciate that. Next up, we're going to hear from John Relman. John is the founder and managing partner of Relman Colfax.
Good morning, and thank you very much. For more than 20 years, Relman Colfax has brought fair housing and fair lending lawsuits across the country, representing plaintiff organizations like the National Fair Housing Alliance, working and the Fair Housing Advocates of Northern California, and working closely with organizations like the NAACP Legal Defense Fund. We are representing the plaintiffs in plaintiff organizations in this suit because it represents as you've heard, a devastating assault on the fair housing gains that have been made over more than 5 decades since the Fair Housing Act was passed. I want to focus my comments on how and why disparate impact has been successful in combating structural inequalities in America and structural racism. And then I want to talk for a few minutes about how and why this rule unlawfully eviscerates the well-established jurisprudence that has been the bedrock, been the foundation for disparate impact over the last 50 years. First, the reason why disparate impact has been successful is essentially 3 critical things that it does in a unique way. The first, as my colleague from the NAACP Legal Defense Fund said, Ajmel said, it ferrets out hidden intentional discrimination. It uncovers overt bias that may be otherwise covered up by pretext or by excuses, by lies. And the Supreme Court recognized that, stating that in some of the heartland cases where local governments or defendants have had the intent to discriminate, that it's been uncovered through the use of the disparate impact statistics that and outcomes that it focuses on. The second thing that it does is that it helps us to combat unconscious bias. Many times, companies or local governments, for example, have rules or practices that are based on assumptions about how people will behave or what they will do that are not necessarily true, but they've been ingrained in us because of unconscious bias or because of the legacy of discrimination that this country has endured. Those assumptions get challenged through the disparate impact doctrine. And where they're found to be unnecessary and there's a less discriminatory alternative, then the law requires that less discriminatory alternative be used. That helps us to move forward and get past this unconscious bias. The third thing that it does is it drives innovation. Because it requires businesses to look for less discriminatory alternatives where a policy has a disparate impact, the end result is that a business has to now invest in taking reasonable steps to see if they can have a different automated underwriting model, for example, or a different policy that gets them to exactly where they want to be, to make the same amount of money, to be able to have their needs met, but do it in a less discriminatory fashion. And as Ajmel said, why in the world wouldn't you do that if you can do it? It's a win for everybody to get what you want, to find more qualified customers, but to do it in a fairer way, in a less discriminatory way. Why wouldn't you do that? Going into the future with the use of algorithmic models that are driving outcomes that we may have a difficult time understanding or seeing, disparate impact is particularly important because these models are the future and they're going to be the way that business is going to identify customers that they want to have, that they're going to market, that they're going to make decisions about whether people can have products and what products they should have. And without disparate impact, we will not have a means to make sure that these models are as fair as they can possibly be, at the same time accomplishing the legitimate goals and needs that they are serving. Disparate impact does that in a way that has been successful for everyone. And that's precisely why Lisa pointed out that major trade associations and major companies and financial institutions have actually stepped forward now and said to HUD, please don't dismantle this rule at this time, particularly. It's the wrong thing to be doing for America. It will undo the progress that we've made. And indeed, in the lawsuit that we have filed, there's testimony to that through declarations and others of individuals who've been in business who say, this has worked, disparate impact has worked. We understand it, we get it, it's something that has moved the ball forward. It's the wrong thing to do to dismantle it. Now, finally, I want to speak for just a minute about what is the basis for the lawsuit and why we believe what HUD has done is unlawful. HUD has dismantled a rule that codified or that attempted to lay out very carefully the basis for disparate impact through careful notice and comment to all stakeholders, and that was issued back in 2013 after very careful review. It was entirely consistent with more than 40 years of jurisprudence. HUD, on its own, decided that it would simply dismantle that rule and rewrite the disparate impact law based on the pretext that the Supreme Court in 2015, in the Inclusive Communities case, had required it to do so. That is simply not true. It is false. It is baseless. The decision in 2015 by the Supreme Court affirmed disparate impact. After many years of waiting, advocates brought this issue to the Supreme Court, and the Supreme Court said, yes, you are right. It is covered under the Fair Housing Act. The Supreme Court expressly decided not to address questions of burden of proof, of pleading standards, of the details, the nuts and bolts of how the matter would get litigated. And it certainly did not say you should radically alter this rule. To the contrary, it said this rule has worked. It is correct. What does HUD do instead? On its own, it has issued now a new alternative. And by doing that, it has eviscerated the rule. It has taken away the touchstone of the rule, which is if there is a less discriminatory alternative that business needs equally well, one must use that. The second thing it does is it creates a pleading standard. For non-lawyers, that simply means that if you're going to get out of the box and get a case started, you have to plead certain things. It requires plaintiffs now to assert that there is no conceivable justification, essentially, for the policy. They have to prove a negative. That cannot be done, and HUD knows it. It was set up to eviscerate the rule. It's a game they're playing, and they know it, and they know it well. And the third thing they do is they create new affirmative defenses out of whole cloth that, once again, even if you could get out of the box, create new safe harbors that the Supreme Court never justified for defendants so that they can now engage in practices that have unnecessary and unjustified discriminatory effect with no recourse. What we are asking in this case, HUD did all of this without justification and with improper notice and comment. They did not let stakeholders know exactly what was going to be in this rule. The final rule has new aspects to it that we've never seen before. So what we are saying is this is unlawful. It is a gross transgression of proper procedure. It is an absolutely patent effort by the Trump administration to take down and undo fair housing protections that have been at the core of our civil rights law and our civil rights movement for the last 50 years. And we're asking this court, where we have filed, to find this rule unlawful and to set it aside. Thank you.
Thank you very much, John. We'd like to now move into some questions from members of the media who've joined us. If there are reporters on the line who would like to ask a question of the folks we just heard from, we'd like to go ahead and give you that opportunity now.
So we have a question from Richard Lawson. So essentially, real estate developers / owners can discriminate because the hurdle is so high to sue. I'll open it up if anyone would like to take that question.
So I'll start off and then kick it off to others. I hope you all can hear me. So what it means is that if you cannot prove intentional discrimination, and intentional discrimination, that's the concept that Ajmal was explaining in his comments. Intentional discrimination, it can be proven in a couple of different ways. So you can prove intentional discrimination if a housing developer or a landlord or a lender says, projects and says that they are making a decision based on a person's race or a person's disability status, or because a person might have children. So somebody says affirmatively or gives some kind of an affirmative statement that they are taking a housing related action because of a person's protected class status. That's one way to show intent. Another way to show intent is by proving what we call differential treatment. So we would have to conduct an extensive investigation, sometimes using a concept called testing, in which we send out testers. These are people who are simulating a real life housing transaction. And we will sometimes send out testers to inquire about a housing opportunity. And those testers are matched on every characteristic except for the protected class feature. So they're matched on their financial profile and all of the other characteristics that would be important, except for the race or except for the familial status. And if those testers are treated differently, that difference in treatment can be attributed to the racial identity of the person or their other protected class status. So that's another way of proving intentional discrimination. The challenge that we have is that as we are moving toward a more highly technical society, and as we are moving towards the adoption of more policies and protocols in the in our housing transactions, it's more difficult to be able to prove intentional discrimination. As Ajmal said, it's highly unlikely that a lender is going to say, hey, I'm not giving you this loan because you're Black or because you're a woman. But a lender could utilize policies that would have the effect of significantly reducing opportunities for people of color or for women. So for example, using minimum loan amounts, or using what we call credit overlays. So tightening the credit lending box so much that it has the effect of excluding protected classes. Well, disparate impact is the mechanism that allows us to address those kinds of policies that end up having a really deleterious effect on underserved populations.
Thank you very much for that answer. Anyone else that would like to ask a question? Please feel free to ask, or you can pop it in the chat. Just want to make sure we get a chance to answer all your questions. So if there's a reporter on the line who would like clarity on something or has a question, feel free to jump in. All right. Well, want to thank you folks for joining us. We will be sending out a full press release with details plus the complaint for reporters who would like to take a look at that. So thank you all and have a great day.
Thank you.